and my learned speakers for this 89th webinar on companies, securities and insolvency law recap of recent regulatory and legal updates. This is being organized by Corporate Professional as its knowledge sharing initiative. Friends, based on the requests received from the various participants and suggestions received from the panelists, we have decided to have the webinar on the first Friday of every month. We are organizing recap of regulatory and legal updates in companies, securities and insolvency law. Shortly we'll add FEMA also. The object of this webinar is very simple, that in our day-to-day life, sometimes we missed out certain things. And in the process, when we are encountering that issue, that the background is not clear to us. To remove this problem of the corporate world, we are started this is a third series. But now what we will do, every month from say 3rd, whatever will come on the next month on the first Friday, whatever new updates from these 3 laws will come and some important case law, we will discuss threadbare with the help of our panelists. And the structure is very simple. Each item we will discuss. The lead speaker will talk about this, and then he will tell what are the earlier law and what is the new law and why this change has taken place, what will be the impact. By doing this, is there any new problems or new interpretational issue is creeping up, that we will take the help of the speaker as well as our experts. So when you are leaving this program, you are clear. Number 1, you are updated on all the aspects. Number 2, you are also clear because these people are doing day and night, advising client, understanding, receiving queries, so they will solve your problem. My advice to all the participants that this is the one program, it can recap the entire thing of the month. And then what we are planning to do, we want to share the updated information of this program through our news buyer, that is a CP Connect, and that will you can receive and you can update yourself with the help of the CP Connect. So you are updated by the program also and by the CP Connect. Today our galaxy of speakers include Amit Gupta, who is a practicing company secretary, insolvency professional. We have Anjali Agrawal, partner and head capital market service, corporate professional. We have Ankit Singhi, head corporate affairs and compliance, corporate professional. We have Mr. GP Madan, founder Madan Law Chamber and M&A Task Force co-chair of ASOCHAM. Then we have Mr. JN Gupta, founder and managing director of Stakeholders Empowerment Service and ex-ED of SEBI. Then we have Manoj Kumar, partner head M&A and transaction and insolvency corporate professional. We have Ravi Prakash, associate partner, corporate professional. We have Mr. Sudhakar, vice president, corporate secretary, Reliance Industry. So you can see practitioner, governance professional, and the advocates, and those who are day and night working, they all are here. And they are not only, they are reading in detail, and today they will do this. So the program structure is simple. First, Manoj will take up the matter relating to changes in insolvency law. Then Ankit Singhi will cover on company law, and then Anjali will cover on security law. And then we'll take up the case law of Tata Mistry, the new outcome which has come. So they will give a presentation, and accordingly, I will ask after their each amendment, I will ask any new questions, new point, if somebody can add. So you will be very clear. And my request to all participants, this program is to create, to clear the doubts, not to create the confusion. So we will try to do this, that whatever point we are coming out, but we have to give the final solution. So over to you, Manoj. You start this, and I'll request all the participants, please share your, write your questions. We'll cover all the questions which you think it is not answered. So Manoj, please discuss about the insolvency law updation.
Good afternoon, everyone. So, as Sir has already discussed, that we are now first covering all the important amendments which has been issued by IBBI or any regulator or government with respect to the various laws. So first we are covering the insolvency law. In the insolvency law, there is no major change as such in the law during this 1 month. However, there has been certain circulars. First circular is with respect to withdrawal of an old circular dated 26th of August 19, which was basically talking about that certain subsection sub-regulations of liquidation process regulation would be applicable with effect from certain date, first date, a specific date. So that date, as these amendments are already incorporated in the regulation itself, the circular became redundant and hence it is being withdrawn. So basically it is talking about 3-4 sections, 3-4 regulations relating to liquidation. The first is with respect to contribution to the liquidation cost, how it will be contributed, that is regulation 2A. So that 2A is already, it is there in the regulation now. Then again, another regulation is 21A, which is presumption of security interest in case of liquidation process. So that is the another regulation. Then third one is 31A. 31A is the basically provision relating to consultation with the stakeholders. For that, there is a committee of stakeholders which is being formed. So that regulation is already there. Then there is a specific regulation 44 specifying the reduced timeline. The timeline for the liquidation process need to be shortened. That was the intent, and hence this regulation was incorporated. So the liquidation process regulation has been amended, and these regulations are there. And there is a specific provision in the regulation itself that all these will be amendment will be applicable for all the matters, liquidation matters which have started on or after 26th August 2019. So earlier section circular dated 26th August 19 was withdrawn, and it is now part of the regulation itself. This is the first amendment. Ankit, next.
Manoj, may I give my inputs here?
Yes, sir.
Yeah.
You know, on 25th of July 2019, because I am referring to this, I wanted to speak about day before yesterday only. I faced this issue before adjudicating authority.
Yeah.
You know, there is a one schedule 1 in IBBI liquidation regulations where the timelines with respect to receipt of the money from the successful auction purchaser have been enhanced. Earlier it was 15 days. With effect on 25th July 2019, it has been increased to 90 days, and it has been said that after 30 days, 12% rate of interest shall be levied till the 90th day.
Yeah.
Right? But now what happens? If a company which went into liquidation, say in 2018, and now the auction is being made, whether the liquidator shall allow only 15 days or 90 days. Because as per the amendment and as per the circular, these amendments shall not be applicable to the liquidation commencements which were before 25th of July 2019.
Yes.
Now in this case, what happened? The liquidator allowed only 15 days. The auction notice was there in the month of May only. Liquidator allowed only 15 days. Now the auction purchaser goes to adjudicating authority and seeks more time.
Yeah.
Adjudicator asked me, I being a representative counsel for the liquidator, that why you have given 15 days, why not 90 days? My answer is very simple, that their new regulations are not applicable to me.
Yes.
I can give 15 days. If your lordship allow 90 days, I can give 90 days, but I am bound by 15 days. Then there was a lot of discussion. I say, if I don't follow the circulars and notifications of IBBI, then IBBI may be after me. I understand the 15 days time is too short a period, but I have no other option. But ultimately court allowed them, gave them 2 more months. with an interest rate of 12%, and that was proposed by me only, and court agreed to that, though I was a respondent, but I gave a suggestion to the court and court agreed to that. I think
Right.
such clarification should also come from IBBI, that wherever a mutatis mutandis should be made applicable. Otherwise, if you today again, if a company which goes into liquidation, today the auction is being made, if you give 15 days time, you are not going to get any response at all.
Right.
I think some places we need to be very, very flexible and practical.
Okay. Rightly pointed out the answer.
Yes, but language of the law is very clear that it will be applicable only to those liquidation process which has started after 25th of July 19.
Amendment,
No, agreed,
amendment is laudable, but at some place it may create hindrance also. We need to consider
Yeah,
that.
so for that, obviously, because it is regulation, judiciary can take, or adjudication officer authority can take different view, like in your case.
No, I think what Madan sir is saying, there is a need. There are a couple of other occasions also where the circulars have been replaced by way of amendment in the regulations, and changes have been made. There, these type of issues are there. So wherever the beneficial provisions are there, the representation can be made to IBBI to make suitable changes in the regulation, giving a clarification that these beneficial provisions will be applicable to the prior processes also, like in this particular case also.
Right.
If
Right.
that is there, then the problem will not be there. Every time you need not go to adjudicating authority. Of course, adjudicating authority is there, but why to unnecessary burden the adjudicating authority with all these trivial matters?
So I think IBBI has made this amendment and this withdrawn the old circular only because there were representations. So obviously, what kind of representation goes from industry side or professional side, that matters a lot. So if it is if practical difficulties are there, it should be said that whenever useful it or beneficial, it may be taken for older cases also. Because many of the cases process started but stopped in between, and then actual liquidation starts even today. That is also the cases, many of the cases. So
very true. There is nothing coming from this withdrawal of circular.
Yeah.
But yes, this is in general. Whenever the
In
law
general,
is
yes.
modified, whenever the law is modified, the beneficial provision should be made applicable from the prior date even. That has to be considered in mind by the IBBI.
No, I mean, there was one more thing which the adjudicating authority said day before yesterday. You know, the circulars may or may not be binding. They said the regulations are always tabled before both the houses of parliament. But the circulars are never placed before both the houses of parliament.
right.
By virtue of circular, if you are going to provide some clarification, that may be very, very harmful also. You need to be very clear while issuing any circular, and through circular, you are going to implement the regulations.
Yeah, in fact, you are very right. There is a settled judgment from Supreme Court which says that circulars are only directed towards the internal working of the government. They are not intended to the general public. Their binding force is only on the department. But in practice, we are seeing that the regulations are done through issue of circulars only. So, anyways, Manoj, please continue.
Yeah.
Once
Sir,
again,
you are muted. You are mute, sir.
Manoj, the point is well taken.
Yeah. Sir, so another notification recently amendment basically is to withdraw various circulars with respect to corporate insolvency resolution process. These are old circulars through which certain amendments, certain clarifications were given by IBBI, but later on they were already made part of the regulations, or sometimes it was found that it is already part of any other regulation. Then in that case, IBBI has made a detailed review of all the circulars notifications made by it over a period of 3 years, 4 years, and then based on that withdrawn several circulars. So the first one is with respect to a circular dated 23rd of February 2018, which is with respect to maintenance of confidentiality of information. So all IRPs, RPs are supposed to maintain full confidentiality of the process, and information must be disclosed only to the authorized persons. So this is now already part of the code of conduct applicable to all the insolvency professionals, and hence it was found suitable to withdraw the old circular. Another circular is with respect to appointment of authorized representative on the committee of creditors with respect to those persons, the class of creditors like home buyers. So for that, there is a specific regulation 16A and 16B in the insolvency resolution process of corporate persons regulation. So there was no use of that circular, and hence it is withdrawn. Next page.
The other speaker, if there's something is not very important and very thing, so Manoj can continue. Okay. If something important and you want to say some additional point, please raise your hand, then we'll talk.
Yeah. Okay. The third circular is dated 10th of August 18, which is basically notice should be given to only limited number of persons or who are entitled to attend the committee of creditors, and that is now already incorporated properly in regulation 17 of CIRP regulations. So it is being withdrawn. Another is also relating to voting.
Manoj, I have my reservation here.
Yeah, okay.
There is nothing like this in regulation 17. If IBA says so, that's not, according to me, that's not right statement. Regulation 17 does not cover anything like that, that only competent persons or the decision should attend the meeting and decision can be taken on spot. Regulation 17 is silent on all these issues.
Yes. So yes, it is very important that it is only talking about who should be given the notice. It is not talking about whether the decision, who are competent persons, and whether they should only attend, and hence so that the decision can be taken on the spot. This is additional things, clarificatory things, which was given through the circular. Obviously, I think it is, as Amit ji was also talking that circulars have no binding effect. You have also mentioned that. Considering those facts, I think they have withdrawn most of the circulars, because there is no such concept that on the spot decision may be taken.
That's right. But they are saying, why are we withdrawing the circular? Because there
logic
is
of withdrawal
regulation 17. And regulation 17 does not cover that. What was there in the circular? So you just can't compare between these two, the circular with the regulation 17. And I tell you what regulation 17 saying, 17(1) capital A, it says the committee and members of the committee shall discharge functions and exercise powers under the code and these regulations in respect of the CIRP in compliance with the guidelines as may be issued by the board. So
where is the guidelines?
Where is the guideline?
Obviously, that was the circular, which is now withdrawn.
Actually, I'll take a minute.
Just a minute. Last year, IBBA came out with a discussion paper on code of conduct for COC members. Even that code of conduct after discussion paper, there was no code of conduct also. I think that proposal stands withdrawn. Then IBBA came out with a circular in January 2018. All the members of the COC will come with complete authority, and so that they can take the decision at the meeting itself.
Right.
This August 18 circular is in continuation to the January 18 circular. But even that circular is not being adhered to. I attend so many COC meetings. None of the COC members comes there with authority. Every time they say we'll get back to our seniors, we'll get back to the committee, and then we'll come back. You know, the banks are taking sometimes 30 to 45 days to cast vote on a particular resolution.
Absolutely.
So that sort of delay is happening in the circulars. They are not giving any importance to IBBA circulars. This is a high time IBBA should come out with something.
Absolutely, what Madan sir is saying is very important, and I completely agree that there was no need to withdraw as far as this circular is concerned, because this was at least a hope that RPs were using to put a pressure on the respective committee of creditor member to depute somebody who can take decision. But now, if that is also not there, how we'll be able to survive, I don't know really. The background is perhaps what Madan sir has also indicated. The regulations got amended, referring the implementation of guidelines regarding the code of conduct for committee of creditors. Regulations have got amended, so that's why they are saying that now, since regulations are in place, we need not have a separate circular because code of conduct would be there. But unfortunately, the guidelines which were supposed to be issued referring to the code of conduct have not been notified yet. That is the problem. So effectively, they are not in force today, and the circular has also gone. Perhaps somebody has overlooked all these things. I can't say that it is intentional. It is overlooked.
Okay.
To, I think, inform to the IBBI.
Okay. Manoj, next.
Yeah. So next one is also as discussed. The circular was saying voting in the committee of creditor. Obviously, the person who is not entitled to attend the meeting cannot vote in the any matter being discussed as COC. So it is the circular IBBI circular is referring. This circular is referring regulation 12, 25, 25A, and 26 of the CIRP regulations. And saying that because there is a specific provisions given in that under the regulations, this circular has no need and hence being withdrawn. So obviously there are, if we see there is no collective information given in at one place, and obviously this was a bit. These circulars were sometimes useful also to get the things done. So I think, but being withdrawn. This is also being withdrawn. Then the next one is voting on behalf of a creditor in a class, like in case of home buyers, such as in case of JP Infratech case. So this circular was issued in December 19, and RP or representative is duly bound to conduct the process, including voting strictly in compliance of the code of conduct as applicable to them. So, and that the provision is there in regulation 16A 9 and 25(6). So it is being withdrawn. That is the contention. Obviously, as discussed, with respect to code of conduct, guidance note is not there. So this, but because it was specific to certain class, it is being withdrawn. Then the retention of record, that is also now amended. Regulation 18 is there. So liquidator is supposed to retain the record for certain period. That is already built in the regulation itself. So this circular has also been withdrawn. Then this another circular is relating to basically matter relating to 39A of CIRP regulations, which is basically the consideration of matter issued by the committee for creditors on the request of members. So member can raise certain issues and which need to be discussed in the COC. So they are saying because 39A is already incorporated in the regulations, so this circular is also being withdrawn. Ankit, next. I think so. These are the basically 7-8 circulars which have been withdrawn. I think besides that there is no major change, amendment. There have been a few cases. Another thing is that the standard operating process is being issued by the basically GST and CBIC, the board of indirect taxes have issued a SOP for their officers. So that is also one important amendment, because it was one of the hindrance in many of the cases. GST dues or customs dues were not being filed during the process, and they are operational creditors, so their claims are not filed, and later on it becomes a matter of litigation or loss to revenue. So this is just to protect the loss of revenue. Detailed process has been framed by the department, and there is a nodal officer who will consider all the companies which are going into insolvency, and so there will be coordination between IBBI and CB or nodal officer of GST and custom authority. And as soon as the company is admitted for insolvency, they will initiate the process of determining overall claim, and they will file the claim before the liquidation insolvency professional, so that he can admit the claim as operational creditor.
So there is a need, Manoj, to have a similar SOP for the other government departments like income tax, PF, which are continuously putting a pressure and we are not able to resolve their issues.
Yes,
So
yes.
similar SOPs should be there for others also.
That's a good practice. Actually, it may not be important for the professionals, but obviously internally departments interdepartmental coordination is also important, and all the government department must abide by this timeline as prescribed under this IBC. Then only the process can be fast tracked and that can be done in a time bound manner.
Even
So that is
SEBI
very
should
important.
also come out with the similar SOPs,
Yes,
because
yes,
we
yes.
struggle in making public announcement even on the BSE platform whenever the company comes into insolvency. Unless BSEs or stock exchanges are supporting, it becomes very difficult.
Right.
But Amit, in case of listed companies, what shall be the outstanding, the listing fee, nothing else?
No, I'm not talking about only listing fees. I am saying because regulation 30 says that it is a information which is required to be disclosed within 24 hours. Say a company listed entity goes into CIRP, you have to disclose. Now, company secretary may be there, may not be there. He may be cooperating, he may not be cooperating. So I, as a IRP, if I want to intimate to the stock exchange, the only source is that I have to go to the listing center and upload the information. I don't have a login ID, I cannot do.
Yeah.
Typically, we have
There are
done, so these
technical
are all
difficulties.
practical challenges. You will not be able to upload the information, and stock exchange will not recognize the information from any third person's email ID.
Actually, in case of GST also, they are saying it's SOP, but SOP, they are internal SOP.
Yes.
Nothing to do with IRP or RP or liquidator. There's
Yes,
internal
yes.
SOP.
SOP is a good idea for everything, and they should make a SOP for all transaction.
But issue Pawan ji, मैं क्या कह रहा हूँ यहाँ पे SOP है for internal, that which officers that deal with what. That's
So
all.
it
Right, right.
is
It
first
is an internal
step.
matter. It is not
It's
a public.
internal SOP.
Yeah, yeah. There are SOPs for all the departments. With respect to
internal SOP creates a system in the entire.
So
process.
I'll say, sir, it is a first step very soon, because they will become aware about the ecosystem of IBC. So they will come forward for the external SOPs also.
Yes.
Next. So Manoj, now these are some important cases during that period.
right. Sir, this is one very important case which has gone in appeal, and the matter is with Omega Laser Products. It is a Dutch company, basically a formal managing director of the company has initiated the insolvency process, tried to initiate the process, and saying that his salary dues are not paid for several years, and which collectively becomes more than 1 crore rupees, and hence this should be admitted. So the matter went to NCLAT, Appellate Tribunal, and Appellate Tribunal has said that this matter cannot be admitted because the total dues is not 1 crore, less than 1 crore, because a certain period of the demand which he is making is basically time barred. So it is again reiterated the fact that Limitation Act is applicable even in case of insolvency matters, and no claim for more than 3 years can be made by any person if it is not an admitted debt. So this is a matter. And
one more issue was there, Manoj, the acknowledgement of debt and the crystallization of debt. So NCLAT mentioned that NCLT is not supposed to adjudicate as to the crystallization of dues.
Right.
In this case, what happened? The MD was engaged and he has got some written scribblings with regard to increment in his salary.
Yeah.
But that salary was never implemented, though it was agreed by the parties that salary will be increased. But balance sheets and the other documents were not corroborating the increase in the remuneration. So,
right.
Adjudicating authority was mentioned that you are not supposed to adjudicate on this aspect, whether the salary.
This aspect. It is a dispute, not a dispute resolution mechanism. So you cannot go for that.
So that's also very important finding by NCLAT.
Yes. I think so. We have discussed another important judgment is with which matter went up to Supreme Court is relating to Noida Authority. So Noida Authority has made claim in many of the insolvency matters of real estate companies which have taken properties on lease from Noida Authority, claiming to be a financial creditor. However, the matter went up to the Supreme Court, and Supreme Court has now clearly mentioned that the dues of Noida Authority is only operational dues and not a financial due. So they can file application under section 9, not under section 7 of the IBC law.
Any view, Madan sir, on this, or Amit?
I think it's an excellent judgment.
Yeah, please, sir, go ahead.
I think it's an excellent judgment if you go through the fine print of the judgment. Or today's time is not there because I can speak for a couple of hours of this judgment. But I can discuss the ramifications or the after effects of this judgment. Now, number one,
I think issue is very limited. I see it very differently. The issue was only relating to the definition of a financial debt, especially related to 5.8D, which was 5.8D and 5.8F, residual clause. So, Honorable Supreme Court concluded that Noida Authority lease does not fall into the framework as is provided in 5.8D or 5.8F. So, it is not a financial debt.
Right.
So, that's how it...
there are a number of reasons have been given. The major reason which they have given is that there are all the risks with respect to the land or of the lessee, and all the rewards are with the lessor. The lessee can't even do anything with respect to this land. Nothing can be changed. He cannot mortgage it. He cannot transfer it. If or any plan also, for each and everything, he needs to seek the permission and approval of Greater Noida Authority. Number of reasons have been given on the judgment. But now, after effect of this judgment is that now the Noida Authority and Greater Noida Authority has applied to the central government that there should be changes in the law, and these authorities' dues should be declared as financial debts. I don't know whether government is going to agree to this pressure of the authorities or not. Other positive impact of this judgment would be now the authorities like Noida Authority or Greater Noida Authority will have to remain very, very active. They cannot afford to be sleeping, that whatever the allottees are doing or the lessees are doing, let them do whatever they want to do. Now they have to have a clear eye on all the actions and activities of all the lessees. They cannot afford now any project to go into insolvency. They cannot afford any company to become a defaulter. They must ensure that each and every real estate project is completing on time. Because if they do not keep these controls, then ultimately, and if they are operational creditor, they are not going to get even a single penny out of the resolution plans. And
so the bottom line,
sir, does
the
this matter
bottom
to them?
line is that at the end of the day, post this judgment, all authorities are going to lose heavily.
No, but I'm going to discuss the negative impact of this. So far, what was happening, the lessees were paying only 10 to 15% to the lessor, the authorities, and rest of the amount was being paid in installments over a period of 7 to 10 years. But now the impact of this judgment may be that the authorities may decide that if you give us lump sum payment, we shall allot you the land. Otherwise, we are not going to allot you the land on installments. Because if they give the land in installments, tomorrow if the buyer, the corporate debtor becomes defaulter, all the remaining balances or outstanding amount may become zero if the company becomes defaulter. So by virtue of this way, it will be maybe a major king's game only, that only big players can remain in the real estate. Whosoever can afford to give 100% payment of the plot to the authority can only become builder, or you need to have a consortium. The small players will be vanished from the market.
Sir, but there is still another thing, whether or not they are operational creditor, they are the owner of the property. So they have the right to withdraw terminate the lease in case of insolvency event. That is there in built in all the agreements. So if the lease is terminated, what the builder would do?
No, that is also a lot of litigation, because in the
Yes.
meantime, you have
Correct.
already allotted the plot, you have already started
Yes, yes.
constructing the flats have been allotted.
Right.
That's going to multiple litigation.
Right.
Sir, even in JP case, the land is actually being transferred to other applicants pursuant to the resolution plan. I think authorities did try to cancel the lease in that case, but they didn't succeed it.
Correct.
Yeah. So no, it is not being transferred. That is not correct to say. It is the lease is getting transferred.
So
So
it's
all
in the
the
matter.
rights
So
they will-
in this
they will-
case,
if they are not able to succeed in this judgment, so they will make the amendments in the agreement itself, lease agreement, where there will be certain specific right. First day or trigger would entitle them to take over the land back. And in all the cases, over the superstructure would may be sold to others, may have right of others, but the land right will remain with the Noida authority in any case.
Okay. So next, I think the financial credit point is. Manoj, any other point? Any other thing, Madan and Amit, which has come, which is not covered here?
I think there are
Major portion we
other
have covered.
judgments also. I think one is with respect to basically, I think
that is, there are so many.
there are other judgments, but okay.
One major judgment I would like to discuss, which has been given by our Honorable Appellate Authority only yesterday. Appellate Authority has allowed that even though the plan has been approved by the COC, an application for approval of the plan has been submitted with the adjudicating authority. Even after that, if somebody files a claim, the resolution professional will have to accept the claim, will have to change the information memorandum, will have to take it to the COC again, and our resolution applicant will consider that. I think that has opened the Pandora box. It may be a never-ending process on everyday basis. Even after the resolution plan approval by the COC, you will be changing the information memorandum. And I tell you, all those claimants who have not filed the claim so far and the plans are pending before adjudicating authority, now all these claimants are now going to file their claims with the resolution professional. And in a number of cases, wherever the resolution plans are pending for consideration, now they will be opened up and there may be further delay. It has already been more than a year or 2 years the plan has been pending before the adjudicating authority, but now there will be further delays in approval of those plans. And even some of the plans may be withdrawn by the resolution applicants because of these additional claims which may be filed and accepted now.
Yes.
sir, any specific
I
reason
think,
why these
yeah.
adjudicating authorities are taking time in approving the plan once they are approved by COCs and submitted with them?
Infrastructure issues, number one. Number two, the number of applications objecting to the plan and number of other applications objecting to the corporate insolvency resolution process. These are the causes of delays. And the moment there is some delay on the part of adjudicating authority, the number of these applications also increases. More number of applicants, and I tell you, 3 days before, in one of the cases, there are 183 applications pending. Adjudicating authority told all the lawyers standing in front of him that please go to IBBI and tell them these 183 applications may require 183 days to adjudicate. जब तक इनको dispose of नहीं करेंगे, we cannot consider the plan. And if we consider the plan pending adjudication of these applications, tomorrow the plan again will be challenged before the appellate authority.
Right.
That is right. That there is a need of the SOP for these type cases also. And you are rightly pointing out the NCLT is opening a Pandora box.
It is not about the NCLT, sir. It is a practical difficulty if the application, any application which apparently or primarily seems to be having certain merit, then it need to be discussed, it need to be adjudicated first. So that takes the extra burden on the NCLT adjudication authority. They cannot throw away all the applications just without looking into it. So this is.
And I tell you, in some cases, I have seen that as per law, the minutes have to be circulated within 48 hours. Now the minutes, if circulated in 96 hours, the disciplinary action is taken against the RP. But when the applications are pending for years together, IBBA does not have any jurisdiction, unfortunately, on these delays.
Obviously, they cannot go against education authority, and
Sir, you
there
cannot
are a
take
few other
right to
judgments also,
litigate.
like
Manoj and Madan sir, Abhi, the case that you told Madan sir, is it not highly unjustified from the point of view of the resolution applicant that he applied for a particular company, or he wants to take over a particular company on the basis of given set of liabilities which have been approved by the COC, and now additional claim comes, and as a result of which everything may go haywire.
Exactly,
Yes.
that's what I said. Because
that
my
is what
plan,
that is the difficulty. Yes,
my plan is based on information memorandum,
information memorandum.
Right.
where the liabilities are absolutely crystallized. Now, if you keep on changing my liabilities, even my plan may also go over.
Yes,
haywire.
yes,
And
yes.
tomorrow I may be constrained to withdraw my plan.
True.
Right. So I think you are talking about KV developers judgment. You are talking about here also NCLT said that in case there is a whether or not the claim is filed by home buyer, if it is in the books of the company, then it must be accepted and put in the information memorandum for by the resolution professional. That is very important. So this judgment is also there. Then recently on 30th, there is a judgment of Kotak in the Kotak Mahindra Bank case, where it is adjudicated by Supreme Court that in case of any recovery certificate, the recovery certificate holder would be considered to be a financial creditor. So that, I think that is in a way clear, but it is being
Manoj,
decided.
now the time of insolvency is over.
Yeah,
Okay,
okay.
we have to cover two more topics, and that is a very some important thing. So thank you all three panelists for relating to this IBC. Now your role will change.
Yeah.
So I will request Ankit to cover up the company law changes which are taken place, and one changes which is taking a headline today in the ET and relating to the Home Ministry approval of the appointment of director of neighboring country. And so many people are working on this, and they are working out and asking questions. Yesterday, ET has also covered my comments on this. So we want to understand all the changes, specifically these changes, Ankit, and I'll take the comments of other people. How this will impact, because the ET is saying there are 390 directors which are foreign directors. So that number is very small. Okay. So out of this, 30% they are saying director from Hong Kong and China. So let's discuss. Ankit, please.
So good evening, everyone. I think most of the updates on the company law side are driven by China and Hong Kong, to be blunt, and they seems to be everywhere, either on the border, either on Russia, or everywhere. So the amendments that were there during last month are more and more so linked with the foreign direct investment regulatory framework in the country, and government has tried to bring relevant references to relevant provisions under the Act to provide a picture which is more clarificatory in nature, apart from some requirements like of pre-clearance, because all other requirements with respect to FDI approvals were still there, and any transactions which require FDI approval, whether it's with respect to transfer of shares or incorporation of company in a sector where you are required to obtain prior approval of central government under the FDI policy, you were supposed to take that approval before you execute that transaction. Now government has tried to bring certain declarations on those aspects in relevant provisions, and apart from taking relevant approval, you have to now also give relevant explanation as whether that approval is required or not, if required, whether it has been taken or not. So the first approval is with respect to amendment is with respect to transfer deeds. So under the Companies Act, the form of transfer deed is in SH4. Now government has made certain amendments in that form to provide a declaration that where a transfer is taking place between a resident or non-resident, and resident to non-resident, where any approval of FDI is required under the FEMA non-debt instrument rules 2019, then if there are relevant declaration are inserted in the SH4, that whether this transfer necessitates any approval, or if there is an approval which is required under the relevant law, then you have to provide the relevant approval letter along with the transfer deed before the board considers the same as a valid transfer. So while the requirement of transfer in case of FDI is there since long, both under FERA and under the FEMA Act, there are both automatic and government route. Under government route, any acquisition by a non-resident requires approval. And where these approvals are required, incumbents used to take that approval and then only proceed to take requisite transfer of shares in their name. But most of these cases, board were not under any obligation to look into the fact whether that approval was required or it has been taken, though generally board always takes such things in mind. But now there is a specific declaration which they've provided in SH4 that whether any approval is required in case of any transfer under the FDI rules, and if such approval is required, you have to provide a relevant approval letter along with the transfer deed. So I don't think it will have much impact. It's more of a clarificatory in nature. As I mentioned, companies which were falling under these criteria are more and so taking approvals and only executing the transaction. So similarly, on the lines of transfer, they have also introduced a provision with respect to where there is a offer of securities through private placement under section 42. Similar declaration is now required to be provided under form PS3, PS4, whether any approval is required in case of FDI rules. And if that approval is required, whether that approval has been obtained by the person to whom the offer is made. While they have made relevant changes in this PS4, I think similar changes will then also be required under any other offer, whether it can be of offer related to ESOPs or offer related to rights issue. Similar declaration shall also be required in such cases because FDI provisions will be applicable in almost all these instances. And under the relevant provision of FDI regulation, if there is an government rule, approval of government is required in either all these cases. So government, I think they would be providing for requisite declaration under these relevant provisions of the law in the times to come. So if now you are going to give or offer PS4 to any person who is a resident of a country or from where he's investing, or he's investing in a sector where there is approval is required under the FDI rules, then he has to submit requisite approval along with submitting the application for subscription under the offer. Similarly, under the incorporation also, if you are submitting any application for incorporation, then you have to give necessary declaration whether any approval under FDI rules is required or not. If such approval is required, then you have to submit the necessary approval letter. And apart from that, if you are a resident of a country which shares land border with India, and you are supposed to be appointed as a director in a company to be incorporated in India, now you have to also seek prior security clearance from MHA, and that needs to be obtained and attached with the requisite form. So earlier, while in terms of investment, the approval was there in terms of FDI policy or FDI rules. But this requirement is a new requirement where now any individual, if he is resident of a country which shares land border with India, like Nepal, Bangladesh, China, even Hong Kong is considered as part of China in terms of regulatory framework in India, then those persons have to first seek necessary security clearance from MHA. And post seeking security clearance, they can only apply for appointment as a director. The only impact that this will increase the time for them to apply for even for incorporation, because any such security clearance is a lengthy process. It has both MHA, IB, foreign embassies, all are involved in terms of the entire process. So that will definitely increase the time that one will take in setting up a company if he wants to get appointed as a director. Otherwise, he have to select some Indian residents for being appointed as a director in the initial phase, and he can appoint for requisite clearance. Post receiving the clearance, he can become a director. So this would be applicable even in case of a company where no foreign investment is there, but for any reason some Chinese resident or any other resident of a country which shares land border is being appointed, then even then the approval of MHA in form of security clearance is required. And security clearance is nothing less than an approval process. It's a very detailed process. Both MHA is involved, intelligence bureau is involved, even foreign embassies are involved. We have seen in other cases of FDI approvals where there is a condition of having a security clearance. So there is all these entities are involved in the entire process, and only then the approval is given by MHA in terms of security clearance.
Ankit, is it having some China connection?
Sir, it is only for China because Pakistan don't incorporate company in India. Sri Lanka doesn't have the capacity at these days to get it done.
Sri Lanka, we don't share land.
No, so yeah, Sri Lanka we don't share land. So like for
It may be
example,
Bangladesh, it may be
Bangladesh,
it may be
Nepal, I think Myanmar, all these countries where we share land border, they cannot take any position in Indian companies.
China, Pakistan, Bhutan, Myanmar, Afghanistan, Nepal, Bangladesh.
Even Hong Kong, they consider Hong Kong as part of China.
So do we share some land with Afghanistan also?
Yes.
Yes, sir, I believe so.
Okay. Some border is there with Afghanistan.
Yes, seven.
Okay.
Let's Ankit should cover this because all are connected points related to.
So similarly, in case of M&A also, they have introduced a declaration. If there is a cross-border amalgamation between an Indian company and a company based out of these which shares land border with India, a declaration is required at the time of filing the application as to whether any requisite approvals have been obtained in Form CA 16. And a declaration is also now added in terms of any other approval is required under the FDA rules in respect to that merger. So if that approval is required, then that approval also needs to be submitted along with the application to the adjudicating authority. In continuation of the same, all the previous amendments were in the month of May. Just lately, on 1st June, in continuation with what they have introduced earlier in terms of requirement of seeking pre-clearance in case of incorporation. Now they have also further expanded that requirement to any person seeking directorships, and if he is a resident in any country which shares land border. In any Indian company, if he wants to seek position as a director, then before appointment, they have to now also seek necessary security clearance from MHA. So before seeking MH clearance, they cannot even apply for DIN. So even if person like this wants to take a position as a director, he definitely needs to have a DIN, unless otherwise he already has a DIN. Then he also need to apply to the DIN authorities along with the approval letter from the MHA that the security clearance has been done. Only then the DIN application will be accepted and DIN will be allotted. And similar declaration will form part of DI2 also, which is the form for giving consent to act as a director.
Okay, so
all these amendments were more and so directed towards the FDA policy and specifically with respect to companies sharing having land border with India.
Okay, Ankit, now I will pose questions to all the person. There are 7 countries, because that confusion should also be removed. 7 neighboring countries: China, Pakistan, Bhutan, Myanmar, Afghanistan, Nepal, and Bangladesh. So it means Sri Lanka is not the neighboring country. So is it exempted? Number 1.
No, they have not said neighboring country. They have a connection with land.
Okay. So the point is, what will be the impact of this? Because FDI came, they have in 2020, they have restricted, but now other people were using indirect route. So indirect route, the fund was coming from other part which is allowed, and then they were appointing the director for controlling. So they want to remove that control system also. And I think if it is going to Ministry of Home, then approval will not come. So my first...
Sir, and what the other way was that they were giving ECBs.
Yeah, all types of finance, they have now curtailed direct control as well as finance. So now Sudhakar has come. Welcome, Sudhakar. So anybody...
Okay. You may ask Sudhakar which channel he has entered, land or sea.
Okay. He's in the air, I think. So I will start with Amit. Will you tell that what will be the impact of this?
So I believe this is a geopolitical issue, and we professional should respect the decision what the government of India has been taking for the integrity and security of our country. Whatever is in the best interest, I think they are the best judge. We may be having only very partial and limited information. We may get pissed off with the amendment what the government is doing time and again. But my only request is that somebody who is looking into the ministry and government, they should look holistically the entire Companies Act or the other corporate law to see whether other areas are also required to be plugged in, so that these pitfalls are not coming in and some bypass route. Because I personally feel that this alone is not sufficient if we want to stop somebody from misusing the channel. This may be one good way, but certainly something more is required. So it may impact the economy of the country also. There is no doubt about that, but nothing comes at the cost of the country and security. Whatever government of India is taking a decision, I think we have to respect. My submission is that. Pawan sir.
Yeah. So, that is right. So, Madan, you have any other view?
I think this decision has been taken to curtail and close the doors of illegal transfer of money, all the channels of money laundering or the Benami transactions. And as Amit said, this may not be sufficient, but I think whatever can be done in the Companies Act, MCA is doing that. Even the other ministries might also be taking the similar action and might be issuing similar notifications or clarifications or circulars or making the suitable amendments. Intention seems to be that only. And if I recall, recently, all of us have gone through that Ministry of Corporate Affairs has given go-ahead signal to ROC to take action against the professionals. And I tell you, majority of the professionals, wherever the show cause notices have been given, or I tell you, even the ED is also involved in those cases. ED is taking action against the professionals. And some of those professionals are actually connected with incorporation of the companies with China connection. So that may be the lead which has given that, or maybe that may be the source which has given the thinking to the government to make these suitable amendments in the law.
Yeah, that's absolutely right, Madan. You are right that it is not only the money laundering issue. They are working out that because China's control through various companies, they want to curtail. I have
come to know even some crime money is also involved in these cases.
Okay. Sudhakar, you have any view? You have to unmute, please.
Yeah. See, in fact, according to me, this is certainly a welcome step from the MCA. But only thing is that this would have happened long before. This is not a reactive action. This is not a proactive action. It would have happened much before, according to me, number one. Number two is that the one country which is left out is Sri Lanka, because they are not sharing the land border with us, but water border. But we all know that China has already intruded into Sri Lanka. Sri Lanka is more or less virtually under its control, because they are heavily borrowed from China. So instead of doing it at a later stage, they would have covered Sri Lanka also. They would have spelled out the countries clearly. Why to say again, sharing the land border or something like that? These are the countries which we are not going to do that. I really fail to understand that why it could not be done. My third thing is that to what extent the money laundering will be curbed because of this. I have my own apprehensions, because these are all the things which are clearly, if anything is coming out, so whether any directors are coming openly, that point of time only you can restrain them. Fourth point is that SH4 has been amended. SH4 is used only for physical transfer of shares. But how about dematting? So opening the demat accounts itself, they have to be dipped in the bud itself. Whenever there is any kind of demat accounts are being opened by FIIs or any stockbrokers and all those things, stringent, stern controlling measures are to be initiated. That is not visible as of now. And as we know that, okay, nowadays you cannot hold the shares in physical mode. Even in case of closely held public companies also, you have to have it in demat mode only. So amending SH4 is not a great effort from MCA, according to me.
Manoj, anybody has any view? Anjali or Ankit, any other point? I think there is one important aspects on the data I have shared. There are 490 foreign national registered as a active director in India. 30% are from China and Hong Kong. So the number is not very big. It's a very small number. If you see this type of law, they want to restrict. Restriction is good because we don't know how much. If it is open, then anybody can come. So the restriction they have put in, which is consistent with the FDI. Now through FDI, you were controlling, so they have stopped. Now through control by your management control, that is also stopped. And I don't think the government will give approval to all the companies which are coming. They will seek and they will stop them. So Ankit, the question is, will they stop this? Because we are bound by WTO also.
So sir, that is why they are creating procedural requirements that will use that procedural requirements to delay, to create some kind of obstacles. That was the issue when they created the requirement of FDA approval. At that point of time, the WTO issue was also raised by China itself. But I think procedural issues is right of every country to create, and they have be doing same.
So Ankit, this is what I was mentioning. This can control only direct things.
Yes, sir.
Indirect things you cannot control with these kind of changes. Sir. These are all piddly changes according to me. Pardon my saying that. Sir. But suppose if China really wants to do something, they can always do it in the indirect route, which you can't stop. As Bhavan was rightly mentioning, you cannot stop because WTO agreements are there in place.
Yes. And there is no dearth of finding ways to do it.
Yeah, I'm sure government is already, because Ministry of Home Affairs is involved and Corporate Affairs is doing limited what they are being directed to.
Correct.
From the MHA.
Amit, my question is, what happened to those company which has already foreign director, these 490 company? Will they stop them?
No, their tenure is till the time their tenure is there.
Something on the vigilance. I am aware about certain vigilance mechanism what the government has created on them. Right now, they have not stopped anything, but they are on the vigil process.
Okay. Anybody has any other additional point in this? So we can move on.
So all that I was suggesting is, as Sudhakar sir has indicated, it is direct only. Even in I am saying direct also, it is not complete. There are many means and ways by which the entry and penetration can happen. I don't want to discuss at this open platform, but certainly government needs to plug those loopholes so that whatever their intentions are, they can be implemented.
And at the same point of time, even the professionals have to become more seriously and more responsibly.
Absolutely.
Yeah,
and I think more importantly, practicing professionals needs to be very vigilant.
Yes.
I think Madan has rightly pointed out Chinese connection, which they have come out and that they have issued notice. These type of companies, when will come to you, you will be more serious on this. And my advice to all that any foreign national is there on the board of the company, they must be very cautious about their credential and other information, other than those who are on the top position.
I tell you, some of the names of some professionals are there in New Delhi Parliament Street Police Station, Hyderabad Police Station, Bangalore Police Station. The departments of these states or cities are after the professionals, the professionals for these transactions.
And out of that, 30 company secretaries are there.
See both, CS both and CS.
Yeah, both are there and 30 company secretaries. This is what I read somewhere.
That's why I said we the professionals.
Okay, now Ankit, next point from EGM.
So on account of COVID pandemic, government has already allowed the corporates to hold the AGM and EGM and even postal ballots through OVM. Now, considering the same and even considering that the committee has already suggested amendments in the Companies Act to make this as a permanent affair, to allow companies to hold their general meetings through video conferencing, the current date has been extended to 31st December 2022. And for both AGM, EGMs and ballot, postal ballot, and as per the same regulatory framework that was issued earlier. So this is there. But I think, sir, Sudhakar sir, for a company like you, do you miss the charm of holding a physical EGM?
In fact, I will put it in a different way, Ankit, about this circular which has come. Technically, under the Companies Act, we can hold the meeting in a physical mode. Because virtual mode is only optional. It is not mandatory.
Yes, it is an optional. It is optional mode. Nobody stops you.
Nobody stops you. Now the question is, listed companies, can they hold the physical meeting and do away with the virtual meetings? Number one. In that case, can the shareholders say that, look, you are depriving us to attend the meetings? Because in case of virtual mode, when you are permitted to hold it, why you are not holding it? In this process, you are depriving us to attend the meetings. So is it so that listed companies have to hold hybrid meetings, or they can hold only physical meetings, or they can continue to hold virtual meetings? That is one question we can debate it, because somebody has recently asked me this question. Don't ask what your company is doing. Still nothing is decided. Okay. I am not even privy to that.
Yeah.
Second question of mine is that the circular which was there in 2020, April, I think 8th, 2020, that circular which permitted you to hold the general meetings, and subsequently the circular in May, which has come to hold the AGMs also in virtual mode. It has also given you the permission that you can circulate the annual reports only in electronic mode to those shareholders who have registered their email IDs. That circular also says that you have to comply with the circular in its entirety. You cannot do pick and choose.
Yes.
Right. Now my question is, suppose if the companies decide to hold the meeting in physical mode, can they say that I will send the annual reports in electronic mode only to those shareholders who have registered their email IDs? Is my second question. These are the two things which I have my own answers for that, but I would like to listen from you, Amit, GP, and others also, Anjali and others.
I think, sir, first, I think out of three, all are or. It should be or, but even I think the circular which you are mentioning, sir, at the AGM, that circular itself has a provision in that circular that you can hold an hybrid meeting
Yes.
in the circular itself. But if a company is holding an AGM or an EGM physically, I don't think it should be a mandatory, unless webcast is 100% mandatory for those entities who are in top 100 as per the LODR. Webcast is 100% mandatory, but I think we can still play with respect to the VC. But you cannot have both the ends. If you are not complying with the VC requirements and that circular and holding meetings physically, then the benefit of sending the annual reports through email should not be available. And I think, sir, while VC at that point of time, the purpose of introducing sending annual reports through email is on account of lot of disturbances in postal services across the country on account of COVID. I think that has now probably gone, and though you can still hold the meeting through VC, it enables larger participation, and to ensure physical distance, it's still a better choice. But from the perspective of email and physical, I think that leeway can still be taken away. Government has just extended what was there earlier. And I think it was a demand from, sir, most of the corporates also, that we should have an extension of the AGM and also an extension in terms of the exemption from sending notices. Because I believe the SEBI exemption on the sending notices through email ended on 31st December 2021, while the EGM was still there till 30th June 2022. So there was still a lot of hue and cry in terms of companies who were holding between this period, whether they should send their report through email or they can avoid sending it and send it was only send through email and avoid sending it. While at that point of time, SEBI exemption was actually not there. So in true sense, if you're holding EGM or AGM during that period, you have to send the copies through email or through physical in terms of the LODR regulation. I think others can also
But Ankit,
add on.
there are many companies who still are okay with holding their physical meetings, but are not wanting to send the annual report.
It's all about cost. It's all about cost. I have heard from some PSUs also who are not willing to spend on printing the annual report, much inclined towards VC.
I think it is high time what Sudhakar sir has flagged. I think these two issues are there. These are some gray areas where the different interpretations are possible and are leaving room for different set of interpretation. But as far as the practicality is concerned, I believe should not there be any difficulty as long as I am complying with the spirit of law. And the spirit of law is that I am giving them the opportunity to participate in the physical meeting, and I have given the annual report through the electronic mode, and they were having sufficient opportunity to take that annual report from the electronic platform. And when the time is there, when we are living in the electronic age, that should not be a barrier. Even SEBI should come forward, and law should itself be enabled to save the environment, to save the trees, and make it the law itself, so that the issues regarding the interpretations are not there. That is my take. Maybe the views can be different. If we go strictly in the interpretation, one can always say, yes, there is a gap because the MCA circular are giving a little different interpretation also, that you have to avail this notification in totality. So maybe somebody can interpret it in a restrictive manner also.
In fact, I say that governance point of view, of course, why the companies are craving for sending the annual reports in electronic mode, because there is a huge savings and cost is there. Similarly, all listed companies are not very rich enough because of this COVID impact is still there on the corporates. It is not like that COVID is over, so all the companies are making good business. It is not so. So out of the 6,500 plus companies what we have, according to me, still about 6,000 and odd companies might be struggling. That is one of the reasons why they said this.
Sudhakar, the point, we have tested this advantage of VC and the digital platform. Now, why can't government make it compulsory? Because the participation has increased. The number of people are coming more. The balance sheet which we were printing, people were opening or not opening, but now the digital literacy is increasing. So why can't we make a permanent of this thing? So there should not be any confusion. Why they are dragging it like 6 months extension, 3 months extension?
I think they should do it. It is a high time. In fact, I do appreciate that you have to say that hold the meetings in virtual mode as well as physical mode or hybrid mode. In fact, that according to me, it is better to do it in the hybrid mode, number one. Number two, so you send your annual reports in the electronic mode only. Make it mandatory, And
in case anybody wants, you can give it to them.
See, second thing, that is fine. Second thing is that now holding the shares in DMAT is compulsory. So whenever you open a DMAT account, they have to mandatorily provide the email account. And that email account, the companies will send the annual reports. Okay. I think if I am not wrong, in company law committee, to a large extent, that indication is already there.
They have already recommended, sir.
Yes, they already recommended that. Most probably, these amendments in the winter session, I think they are going to make this amendment bill. I am sure that it will come in that definitely.
But why this issue should be is required to be flagged? Because till the time regulation 36 is modified, I think we'll still be struggling with the problem. So maybe Anjali ma'am can take it up to SEBI to make a permanent change in this regulation 36.
See, one thing is there, Amit, the way, if you understand SEBI, they are always corporate friendly and all, and they go in line with Companies Act to a large extent. So once Companies Act gets amended, I'm sure that SEBI will also be with open heart. They will make these kind of changes in the listing regulations.
Let's
Agree.
make
Yeah.
let's make it this. Yeah, Manu, Madan.
That's one point. I will go beyond what Sudhakar said. Even those shareholders who are holding shares in physical form, they are also having email IDs.
Correct.
So this
Yes.
should be made mandatory, because and I don't agree with Amit that Anjali to make a representation to SEBI, because Anjali is investor friendly, not corporate friendly. She wants everybody should be sent an annual report in physical form. My humble submission is it should be sent to everybody in electronic mode, and if somebody is making a request, but for making that request, a time period should be there. Because every given point after 3 years also you can't ask if you please give me annual report for the 2017, 2018.
I'm not agreeing on this point. There is a one issue. There is a your types of people, those who are totally literate of digital.
No, that's not, you can't have thousands of copy printed at every point of time. It needs space also. There may be space constraints also. Yes.
Right, but you can't deprive the people who cannot read through digital mode.
No, that's what I'm saying. Give them a time of 6 months, give them 3 months window. Within 3 months of the AGM, you can apply and you will get a physical copy. I'm saying that.
May I intervene?
No, I think
May I intervene?
Okay. The champion.
Gupta ji, namaskar.
Namaskar.
Sir, good
Who
evening.
owns the company?
Shareholder.
So you say that the person who is employed by the shareholder should have the authority over the employer. So shareholders are supreme. If the law provides, the shareholders will have to be serviced. So I would say that the provision should be that if I have given that I want physical report, period, whether it is for this year or for next 20 years, I want it unless until I change it.
Okay.
one,
Yes, agreed.
I think we can go on to this topic. So now Gupta.
so one more thing which Madan sir said, that I am investor friendly.
Anjali, no comment, Anjali.
No. It has arisen out of my experience of other corporate actions. When we do a buyback or a rights issue, we see so many cases wherein people still don't have their email IDs, or they do not have the their shares are still in physical. So they want those letter of offers in the physical form, in hard copy. So that is why I feel that still there is a generation who's comfortable holding the shares, holding the real document.
Okay. Well taken. Now, friends, Gupta ji has also come. We have to discuss that Tata Mistry case also and security lawyer. So Ankit, please move on. So in case there is some very important point, we'll discuss. Otherwise, we'll move on.
Sir, the last is with respect to CSR, Form CSR2, which was for year 2021, which was already extended till 31st May. The date has been further extended to 30th June. And for year 21-22, now you can file the CSR2 after filing the financial statements for that year up on and before March 31st, March 2023. So this is another extension which is there. And this is another important point that there is a circular of MCA directing to ROCs not to allow registration of Section 8 companies as microfinance companies, while the corollary is that RBI Act specifically permits Section 8 companies to carry on the business of microfinance. And recently, they have also exempted these class of companies carrying microfinance business if they are meeting a prescribed set of parameters to obtain even registration. But to the contrary, MCA has given directions to ROC to not to allow certain registration of Section 8 as microfinance. And we Indians have the habit of finding some way. So a lot of them were incorporating Section 8 companies, and then after the incorporation, they were amending the objects and introducing microfinance as an activity and reaching out to ROCs where ROCs were approving. So considering the same, they have given fresh instructions to ROC to not to allow such activities to microfinance activities to Section 8 companies. Difficult to understand how two regulators are on very two different sides on a same topic.
Ankit, just to add one more aspect, what about existing Section 8 companies which are already into microfinance
So
activity.
they are carrying the business, so no such prohibition is there or bar on there to stop them. They have taken the requisite registration from RBI, so they are well and so.
No, they
doing
have
the
not
business.
taken. They have not taken. They are not required, and they have not taken. There is no requirement of registration from RBI as far as Section 8 company.
Sir, I think there is a requirement earlier.
No
The only benefit they have is they can have with a lesser net owned fund. Now, recently they have introduced new criteria pursuant to which you need not to take any approval if you are meeting these specified parameters.
I'll tell Ankit. The circular says, RBI says that if you are a microfinance institution, NBFC, MFI, registered with Reserve Bank of India, then you come in a priority lending sector of a bank. So bank gives you the priority as far as the lending is concerned. If you are a Section 8 company, you don't get a priority for the lending. That's the only difference. Otherwise, there is no requirement of going for registration of a Section 8 company with the RBI.
Amit, please clarify one thing to me. My understanding of Section 8 company is that should be for charitable activities, promoting art, culture, blah, 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 and all, but not to engage in business activities as such.
No. Section 8 can do a
restriction is only on distribution of profit.
Yeah,
can I come in here to resolve the confusion? The Section 8 doesn't mean charitable or social.
Absolutely.
Section 8 prohibits only distribution of dividend to the shareholder, one. And secondly, if the shareholder himself is employee, then there is a restriction on the reasonable remuneration given to the shareholder. That is second. RBI comes into the picture not because you are Section 8, but because you are tempering into the domain of the control of RBI.
Yes.
So if you are doing any activity which is under control of RBI, whether you are LLP, Section 8, limited, non-limited, anything, you will have to seek approval of RBI. So you are seeking approval of RBI because you are doing activity which is the domain of RBI, not because of Section 8.
Absolutely. But here the point is that, Gupta sir, what I was trying to indicate is there is no RBI circular which mandates registration requirement for a Section 8 company undertaking a microfinance activity. It is only if you are registered as a NBFC, then you are required.
No, I would
think,
say,
sir, there is.
I would say this must be a gray area, because the moment I am doing microfinance activity, all rule, whether RBI requires or not, should be applicable to me. If RBI requires microfinance should be registered with them, then it is to be registered with them regardless of which entity is doing that activity. So we have to be clear whether the RBI requirement needs registration of all microfinance or selected microfinance.
Why I am saying so? Because RBI regulates NBFC, MFIs. RBI does not have any regulation for microfinance activities.
No, sir. So all institutions which carry microfinances are categorized as NBFC, MFI.
Correct.
Under the RPA regulations.
I would say then this is a gray area, and all MFI should be classified as NBFC MFI. Otherwise, what will happen? I will be doing MFI work without any registration, and then tomorrow you will get a Ponzi scheme.
Yeah, absolutely. Your point is valid. It is a gray area as on date. So that's why, Ankit, I am saying that perhaps government has taken a via route to stop that activity. But then
they should allow these activities to Section 8 which get registration from RBI.
Yes. You can't get the registration. RBI won't give the registration to Section 8 company. You have to have a NBFC criteria met. Otherwise,
Amit sir, I don't think that is possible, because as I mentioned, recently RBI has come out with a circular exempting Section 8 companies from the requirement of registration if they are carrying a business of MFI and meeting prescribed criteria. If they are not meeting the prescribed criteria, they have to seek registration.
Yes,
sir. Counter to that only.
I would say that if you send me that circular, then I will take it with RBI and tell them that
I will, sir.
I will.
So moving along
is
another case. I think this case was handled by our M&A team, where there was a M&A merger application between a listed company and its subsidiary, and we were able to seek exemption from the adjudicating authority from holding all the meetings of creditors, I think shareholders,
Yes, Manoj,
even without requirement of NOC. I think
So
if
Ankit,
Manoj
I'm
is
here.
there,
Yeah,
okay,
I'm here.
yeah,
I'm here.
Manoj.
Manoj,
So
Manoj, before
Yeah.
this, friends, as you are aware that normally when there is a calling of the meeting, even for subsidiary company, the NCLT always saying call the meeting of creditors, call the meeting of shareholders if the listed company is there. So we have done the recent transaction, and Manoj will explain to you that the NCLT has exempted all types of meeting, and that is a one landmark decision which will be helpful for all subsidiary companies. Manoj, please explain.
Yeah. So good afternoon again. So here basically we have been complaining that NCLT is taking a lot of time in M&A mergers, acquisitions, merger demerger processes because of and further to that there are the timeline with respect to holding meetings is also quite large because generally the order is reserved and then order is passed and then a notice and a meeting process would take 2 months. So it is a 3 months process. It is a merger of holding company and wholly owned subsidiary. Generally, it could have been covered under Section 233, which is the fast track merger route. But because a listed company is involved and under Section 233, there is a requirement of approval from 90% of the shareholders. So, which is very difficult in case of listed company, and hence no listed companies are going through this fast track route, even in case of merger of wholly owned subsidiary. In this case, we have applied for merger of holding and wholly owned subsidiary case, and we have used the recent judgment of Ericsson in the NCLAT matter, where NCLAT has allowed dispensation of all the meetings based on the fact that there was no impact on the shareholders or creditors of any of the company because it is already a wholly owned subsidiary case. So same judgment we have quoted, and the NCLT bench of Delhi bench has agreed to give exemption from meeting of all the shareholders, creditors of both the companies without their consent. So that is a one unique case, because earlier in May last year, there was a judgment of principal which said that under the Companies Act, the NCLT has no power to grant exemption from the meeting of shareholders. However, in this case, they have allowed even without consent on the credit. In the most of the cases where we were seeking dispensation of meeting based on the no objection from all the shareholders in the form of affidavit. Similarly, we were filing the no objection from all the creditors in the form of affidavit. However, in this case, we have not filed any consent, and we have just prayed because it is a holding and subsidiary case, and all liability and assets are already in control of the same person. There should not be any need for meetings, and NCLT has agreed to our contention and allowed the dispensation. So in this way, we have saved more than 3 months' time, and that is a very good thing. If this type of forward-looking judgments are coming, then process can be fast-tracked, and it will be very helpful to
Manoj, if we can
industry.
get a stamp of the Jain Gupta ji, then I think this will be a all times to come. There will be law. Gupta sir has some different view. Please tell us, sir.
Yes, sir.
So I was not hearing this because it was not topic assigned to me. So sorry, dear, I missed it.
I'm just asking this. The NCLT has given exemption to all types of company in subsidiary companies case with this logic that the company and everything is in the books and they are the owning the company. There's no impact on this. No impact on shareholders.
I disagree. For the reasons, one doesn't know what are the liabilities in the subsidiary company, and subsidiary company is a separate legal entity. So if something subsidiary company goes bust, doesn't mean that the parent will also go bust. The loss will be only of that much, unless until you have guaranteed everything. So when I saw this judgment, I was surprised that how come this type of judgment has come, because then it is totally ignoring the separate legal person that subsidiary is.
Sir, this kind of judgments were already there even in case of older company law, and high courts have given such similar exemption in many of the cases. Considering the fact that obviously they have looked into the fact that there is no dearth of assets in the company to pay off all the liabilities. So based on that, they have given exemption from the meeting of creditors. However, shareholders meetings exemption were also granted in old cases, but last year the principal bench has contended that under the company's law, new companies, that there is no provision of exemption.
Manoj, I understand all that, but I always say that law is the servant of the logic.
Yes.
When logic is important, the law should change. I am telling you that logically, the subsidiary is a different legal entity, and you can't treat it as own. Even today's time, father and son are two different entities. So the father cannot control the son, or son cannot control the father. So same thing has to happen in subsidiary. That is one. The second thing is this: the same thing will happen also if you are hiving out something to the subsidiary, because it is one and the same thing. But once you hive it off to the subsidiary, and then the subsidiary hives off part of it to some person at the valuation which is very low, then the shareholders will lose, as it what companies are doing. So in my opinion, any decision of subsidiary level is also as important as the parent level.
Manoj, I have an issue here. Dispensation with the meeting is fine, that may be granted, but without written consent, why the
Yes.
consent should also be waived? Because
Yeah,
why the consent should be waived? Taking a consent is not going to take time. If you're saying that we are going to save 3 months or 6 months, that's okay. If there is dispensation holding of the meeting.
sir, in case of listed company, it is impossible to seek consent from 90% of the shareholders. So that was not practical. That's why meetings were happening in all
Manoj.
listed companies.
Yeah, Manoj,
Yeah.
if the intention is to the save time, the first thing that NCLT should do, that when they first act as a post office, the company comes and they say, okay, the company should have a shareholders meeting. This process can be done away with, and the company should be allowed to call the shareholders meeting simultaneously while approaching NCLT, so it will save time. The second, they should expedite their own process. They take years in clearing a compromise scheme or arrangement scheme. They should work fast, and then the time will be saved. Today you have got 6 months or 8 months or 1 year, the cases are pending. Do it fast, and then time will be saved. Rather than cutting down on the shareholders or creditors' right, cut down on your rights.
Yeah.
Just a small point, how you view the mergers and amalgamations which are taking in foreign jurisdictions, which are nothing but a contractual arrangements.
Contractual arrangement, yeah. That is what that
अमित ऐसा करते हैं, इस पे डिस्कशन करेंगे क्योंकि अभी टॉपिक बहुत रह गया है और टाइम बहुत कम है. Okay, so this is one point, no doubt. Gupta ji has his own point, and he's always talking about the governance issue. I'll just take up the securities law changes, but then I have 21 questions and Gupta ji's things also. So Anjali, please cover it in brief, these things, because something is clarification. Yeah.
Yeah. Good evening, everybody. So SEBI is working more towards streamlining the circulars or the regulations which are already in place, and whatever circulars or whatever amendments have been there, they are majorly in the line of streamlining the things. So with regard to relaxation from dispatch of hard copy of the annual reports, we have already discussed in great length that up till December 31st, these relaxations have been granted by SEBI. The only thing which SEBI wants is that the advertisement that is given must contain a link of the annual report, and the requirement of sending proxy forms has also been dispensed with up till 31st December 22 in case the general meeting is being held by the electronic mode. In case of transmission of securities, it was being felt that the RTAs are asking for a lot many things which may or may not be relevant in case of transmission. So SEBI has tried to streamline this process and simplify this process. And if you go through this circular, it has been drafted really well in the sense that they have envisaged every possible situation wherein if the shares were held in a single name, or the person was having a nomination, or the person was not having a nomination, whether the person the shareholder had a will or not a will, if the shares were held in physical form, in case the shares are held in joint name. SEBI has provided all the required documents which are needed to be submitted in case of these transmission, in case of all these situations, and whatever situations it could envisage, it has envisaged, and it has provided the list of documents required for each of these events. Ankit, next. Now, this is with regard to debt listed companies. In case of debt listed companies, a security cover certificate is needed to be submitted by the company, by the listed entity, to the stock exchanges. There was a format to it, but now the said format has been revised, and even the timelines have been revised. The new format which has been provided provides for a holistic picture, attempts to provide a holistic picture of all the borrowings of the company and the status of encumbrances on the assets of the listed company. It has also been provided that the certificate is required to be given quarterly to the stock exchanges, plus the statutory auditor is required to certify the book values of all the assets. This statutory auditor certification requirement was not there earlier. For the first time, even the formulae have been mentioned, given in this circular to calculate the security cover ratios, so as to so that there are no ambiguity in the presentation of the said certificate.
Sir, yeah, I'm coming directly to you. You must have faced lots of companies which are giving presentation in such a manner that everything they can hide and everything they can show it in different manner. So what will be the impact of this certificate? Gupta sir?
Yeah.
What will be the impact of this certificate?
Actually, I am not aware of this, so I would not be able to.
Amit, Manoj.
Actually, it is nothing, but I think they have streamlined the requirement. What was there, I think, in a haphazard manner in different regulation. Now they have synchronized, because there was a confusion after the amendment that came in October 2021 as to what they have to follow with regard to the security cover. One regulation was saying something, the other was saying something. To best of my understanding, what I am able to read out is only synchronization. That
more responsibility has been cast on debenture trustee.
Correct.
Even it has to do a complete due diligence before issuing any such certificates.
Correct. That is in addition, because they were not able to monitor that.
No, I think as far as this thing is concerned, debenture trustee liability or requirement, I am glad that it has been done, because till now debenture trustees were only acted as a post office rubber stamp, earning their fees and doing nothing. And then when something happened, they say, oh God, this has happened and I was not kept on. So when they do this, then they know that every time they are providing that there is a security cover and they have done proper calculation. That is what is the intent, and I am happy about it.
Perhaps a bit of effect of DHFL also.
Yeah, I think it is some total of many things that has happened. The problem is this, that most of the time I am debenture trustee, I am something because I just want to earn my fee doing nothing. And that has been happening because everybody will come and bring you a certificate that give us a security cover certificate. I will sign blindly and collect my fee. Now the issue is this, now when I am given this responsibility and onerous, that I have to own this responsibility also, that I have done the calculation, I check the calculation, then I will probably be a bit more careful. The problem, as I always say, that in this country, unless until I get a hammer, I don't wake up.
Okay. And Anjali, next.
Yeah. So the next important circular is with regard to streamlining the process of rights issues with regard to rights entitlements trading. So rights entitlements, in case of every rights issue, the rights entitlements are traded on the stock exchanges with effect from 2020. But presently, the law requires that that RE trading period should close 4 days prior to the issue closure. But in few of the cases, it was observed by the regulator that there were certain holidays or certain off days between the issue closure and the RE trading closure, as a result of which the shareholders or RE traders were not able to have those REs credited to their demat accounts, and they were not able to apply. So this timeline has now been changed to 3 working days prior to the issue closure. This is more in the requirement because that RE trading is on a basis of T+2 settlement. This is a welcome move from SEBI's side.
I would add that I want 2 more things to happen.
Yeah, sir.
The RE should not be traded with the normal equity market,
Totally
because
agree.
many investors do not understand and they feel that the share is suddenly selling at a much lower price and they buy, they do not understand what is the liability. The second thing is that even after the trading closure, there should be a window for 1-to-1 transaction between the investors, so that those people who could not sell their RE in time can always do off-market transfers. There should be some sort of facility, because what is happening, I understand that many investors, they have bought the RE from the market without understanding it, and they are stuck because they do not have the money to pay for the right issue amount, and they are stuck. So some sort of a window should be provided even after the RE is closed on the stock exchange, which should be facilitated for trading. And although it will be very difficult for SEBI to do it, but this is what feedback you should give.
Okay. That is absolutely right, sir.
Yeah. With regard to your first suggestion, we were having a word with the stock exchanges, and we also suggested the same thing, that there should be some window or some caption on the home screen of that RE trading, that this is only the rights entitlement, this is not the normal script of the company, so that the poor shareholder gets to know that he is not buying the share, he's just buying the entitlement. This is a very common problem that the shareholders have.
Next, Anjali.
Yeah. Now, issuance of duplicate share certificates, just like in case of transmission of shares, duplicate issuance was quite a complicated task till now. SEBI has tried to simplify the procedure and has mandated certain documents which have to be there for issuance of these duplicate certificates. Standard formats have been prescribed, simplified process, and the checklist has been curtailed. Ankit, next. Yeah, they require a copy of the FIR or EFIR. Newspaper publication has to be there. Affidavit and indemnity have to be there. A new insurance policy which has been provided in the circular is company has to take a special contingency insurance policy to safeguard its interest. We'll have to see what exactly does that mean. Special contingency, maybe to safeguard a situation wherein somebody applies for a fake duplicate certificate issuance. Probably this is what we can understand right now. Surety for insurance is not required. They have removed the concept, and it is exempt from the process if the value of the shares is less than ₹5 lakh.
Okay, Anjali, go back. Ankit, go back. The most important advantage of this SOP and this format of documents which they are giving, because RTAs, they are asking as per their own desire.
Right.
So, and then they ask information and the further information. Now it is a SEBI's paper. So on that basis, you can submit a document, you can ask. So they have simplified the process. FIR is there. So it's create that you have done some, you have some proper.
Lost a certificate, yeah.
Communication is also communication to the public. Affidavit indemnity is taking care of the only thing is the special contingency insurance policy to safeguard listed company. That is the one point. Who will take this insurance policy?
The listed company.
So listed company will take for this type of problems which can come in future.
Yeah.
Okay. And they have removed surety and exemption from process of if value is less than 5 lakh.
Yeah.
Both the things.
Only thing is we need to see that whether that kind of a policy is available in the market or not.
Yeah, it should not have.
Because in case of fixed deposits, if you remember, it was extended by 2 years. Ultimately, it has been withdrawn because no insurance company came forward to provide such kind of a policy.
Yeah.
Okay. Next.
Now, this is the most important of all the amendments which has come in, that review of the Asba mechanism for IPOs. We all know that Asba is mandatory for retail investors. The Asba life cycle, if we see, 2009, SEBI introduced the concept of Asba. It was applicable to all investors except QIBs. In 2010, it extended it to QIBs as well. In 2018, UPI, Unified Payment Interface, was introduced for retail investors. But SEBI observed that in spite of all these provisions, many of the HNIs and QIBs were not investing through QIB, through the ASBA route. And in many of the cases, after applying, they were even withdrawing their applications, seeing the response that was there in the market to the said public issue or in the gray market. So now they have mandated that ASBA applications will be processed only after the money is blocked. This is applicable even for QIBs and HNIs, thereby making the entire process little stricter, but yes, an investor-friendly process, wherein the investors would know that which QIBs are investing in a particular issue, and then only they'll also feel inclined, or then also they may put in money in a particular public issue.
Anjali, does it mean they'll not be able to withdraw their money before the allotment is made?
They can withdraw their money, but their money will not.
I don't think, sir, they cannot, because it's blocked. They cannot be.
No, I'm sorry to say that.
No. Even retail investors can block. They can withdraw their.
No, ma'am, it cannot be. Once it is blocked, then what's the purpose of blocking if you can withdraw?
GP, I will tell you what was happening was this: the application was made with Asba, and then it was told that it is blocked, but actually though no money was blocked.
Right.
Okay. And which is very surprising, but as the name itself says, that Asba means application supported by blocked accounts. But then nobody read it, so it was ASMA, ASMB, application supported by merchant banker.
But
so
I
the
think,
merchant
sir,
bankers allowed the application without blocking the account.
Yes, I think there is the reason, because at times I also applied, and when you create through apply through UPI, it asks you to create that mandate. So even for applications where I have not created the mandate, post the closure, I received a mail from the RTA that you have not been allotted any shares, no amount blocked. So if I have not actually blocked the amount, the application should not actually been considered in the first instance itself. I think this is what happened with LIC IPO.
So actually, basically, it was a practice which was mala fide right from the word go, and it was happening, and now it is being curbed. That's all.
Right.
Now, my question to Anjali and Ankit. Ankit, सबसे पहले तो I must compliment you. If LIC you were not allotted share, you saved a lot of money.
No, I was allotted shares.
Okay. Number two, my question to you: once a retail investor applies for an IPA through ASBA mode, if I apply the rules of Contract Act, is it offer or acceptance?
I think the offer is from the company, acceptance is from us.
No, according to it's an offer. The moment the shares are allotted, that is acceptance.
GP, you got to understand, the Contract Act is a general law. SEBI IPO allotment process is a specific law. So a specific law will override the general law.
No, sir. The contract will remain a contract. The rule of offer acceptance will always be there.
You may not agree, but I would say that specific law will always overrule a general law.
No, I still fail to. I have not got my answer.
Sir, but in case of, for example, offer for sale, it's an offer from the seller. In an OFS, it's an offer from the seller, and you accept that offer.
Whether it's OFS or IPO, the moment I make the application, before the shares are allotted, transferred in my name, do I have a right to withdraw my money or not?
No, you cannot
once
withdraw.
It is blocked, you cannot.
You cannot withdraw.
Once it is blocked, you cannot.
Because if you even go for the contract law, then the contract law, if the seller has made an offer and the buyer has made a response to that offer, and if the offer has been posted, then you cannot withdraw. If the offer was not posted, you can withdraw. Now, by blocking, you have closed all your doors for blocking, for withdrawing. it is the only option which is the seller to sell to you or not.
And sir, if you are allowed to withdraw, then it will create a lot of practical issues for the process to
Don't bother
complete.
about practical issue.
Yeah.
Answer GP in the legal language he wants. He is not bothered about practical issues.
I'm still not convinced, sir. I'll have a detailed study on this.
Okay, when you
I'll
come to
back.
Mumbai, I will convince you.
I'll definitely, sir. Jaldi se.
Next, Anjali.
Raman, we got to move to that case first. Otherwise,
Yeah, I think all other is.
I think, sir, this is a simplified thing. There isn't anything much in it. We can move to the Cyrus mystery case. Yeah.
No, sir, no, I will structure like this because other people can comment. You can give the comment because this case has come in detail, but later on again it has come. So I'll request you just give your perspective about this case. Then I'll take up question answer.
so Mr. Madan, you start, please.
No, sir. You will start. मैं तो intervener हूँ, sir.
No, I am always the contra party. So then Ravi,
I think sir, Ravi can start. I think he has prepared something. If
Ravi, you can start with very quickly.
Yes, so we all know that this case made much ado across the country and across the judicial corridors. It started because of the removal of Cyrus Mistry from the position of executive chairman on the board of Tata Sons and thereafter as a director after 3 months. Interestingly, they filed in NCLT, and at the first instance, their application was rejected because they were not meeting the eligibility criteria. And they went to MCLAT.
Ravi, can we have discussion in between also on the issues which is being discussed at that point of time? My observation here is why government does not clarify the meaning of this term issued capital in 244. Why number of cases on this particular issue of issued capital? Because in this case, what happened? Cyrus Mistry says, I hold 18.5%, and Tata say, no, they hold 2.5%. Why these things are not clear? These things were there in 1956 Act also. Now they have been repeated in 2013 legislation also. Why simple clarity? They can't specify what is the meaning of the term issued share capital, or it will include so and so, so and so, and so matter ends. Lot of litigation happened on this issue only in this case.
Sir, Mr. Madan, with request to you, आप बाकी सारे जज और वकीलों के पेट पे लात मत मारिए. सारे केस अगर सारी चीज क्लैरिफाई हो गई हिंदुस्तान में तो कोई भी केस नहीं बचेगा.
सर मैं भी उसमें इंक्लूडेड हूँ लात मार.
हाँ तो इसीलिए तो बोल रहा हूँ अगर IBBI बिल्कुल सिंप्लीफाई हो गया तो आप क्या करोगे? I will say I think probably there has been some attempt to clarify it after this order, and they have made what is the issued capital. I think Amit can correct me if it.
मेरे ख्याल से अभी भी नहीं है.
Sir, मेरे ख्याल से time is short. We can't discuss much. Better we can take the important views from your.
Okay, then I will tell you. Then I will not go through all the process. I will tell you what is the genesis of this case. See, if Mr. Mistry was removed, on face of it, it was very bad decision. It was a bad governance that you are removing a person before his term has ended, and that too in a board meeting. So on first day itself, it gave a very bad taste in the mouth. But what happens after this removal, when things started coming in the public domain, then when you look it back to the history, then you find that probably the decision was right. Because what happens when Mr. Mistry, in his mail and letter that was released after 3 years, he talks about hundreds of the issue. Then you see, he says, I will give you a couple of examples. He says that Tata Steel was sitting on some billion loss and the liabilities are understated. Then my question to him was that either you are guilty of signing a wrong balance sheet, because you have signed that balance sheet as a chairperson, and you have said, so today you are telling the investor that I have wronged the balance sheet, I have understated the liability. Other thing was that if this statement is wrong, then you are creating a fear in the mind of the investors. So you will be caught under prevention of fraudulent and unfair trade practice because you are creating a false market. So having said that, so these are the one instance. The second, he said that Indian hotel had legacy problems and blah, blah, blah. And Nusli Wadia also joined in the music with him. Now, if you look at Indian hotels, Mr. Wadia had been director for 13 or 15 years there. Mr. Mistri's brother was director there. So the issue is this, that if you were there insider, you never found a problem. It is only when you're out, you found a problem. That means it shows your character. The third basic issue was this. The question that I asked, that where you executive chairperson of Tata Sons as a representative of Cyrus Mistry and Company, whatever Shapurji Palanji Mistry and Company, or you were there as an independent selected person regardless of your position? And the answer is that he was selected as Cyrus Mistry individual, nothing to do with 18% of whatever percentage shareholding. So once you were in that position because you were an independent selected, so then the rights that accrue to you as a shareholder can never be mixed with that right. So my question was that initially on the very first day, I was very much against his removal. But when things started coming in public domain, then I found that because of his behavior, because of the threats that he has done, and because of the wrong insinuation he made, probably he was not the right person, and that's why the removal was justified.
Ravi, you have some point?
Yes, I agree with the heads up that Gupta sir has given. It was due to the character. In that remark on the character of Mr. Cyrus Mistry could be found in NCLT's order. It got somewhere diluted in NCLAT's order, which was ultimately overturned by Supreme Court. In Supreme Court's order of March 2021, you would see certain remarks to the extent of saying that we created tribunals so that delay can be avoided. But in the way these applications and rounds of applications were filed in this matter, they say that the discipline of judicial adjudication has been avoided. So, in why Mr. Mistry was removed? He was removed because he had lost the confidence of 7 out of the 9 directors on the board. And because of the serious charges of leaking information from the company or regarding the group to various outsiders and authorities. Thirdly, the paramount question which Supreme Court considered, and it got considered at the Supreme Court level, not anywhere below. They said that ultimately the shareholders of this trust, the shareholders of this company, Tata Sons, are charitable trust, philanthropic charitable trust. So we do not see in any philosophical rhetoric that there could be an inherent or internecine prejudice between the majority and minority shareholders. Such a presumption we are not going to take, because considering the setup or the factual matrix or the organizational structure of this group. Now, you also see when we read the order of 2021 of Supreme Court, what were the competing differences between the approach in the order rendered by NCLT in 2018 and that of the NCLAT, which was rendered in appeal. So while NCLT had adjudicated on each and every point, starting from Chorus to Nano to Air Asia, and there were all kind of allegations in this matter, all kind of scurrilous attacks. In fact, so much so, one of the observation in NCLT's order, you would find that it was alleged that through Air Asia deal, some terrorist organization was financed. And that was without shred of a paper. So therefore, but when the case went in NCLAT, the focus were on only 3 points. One was removal of Mr. Mistry from position of executive chairmanship. Secondly, the powers, whether the articles the clauses of articles of association were per se oppressive or prejudicial. And third, whether there was any lack of probity in the way the board of directors were conducting themselves. So these were the three main contours on which NCLAT focused. NCLAT reversed the direction, the order of NCLT without challenging, without reasoning against the ratio given by NCLT. And that was the biggest fatal point, which didn't work for Mr. Mistry and team in Supreme Court. This was where the whole case fell apart. This was the biggest legal fatality in the order of NCLAT, that they did not give any independent reasons for overturning the decision of NCLT. So if I were to summarize this in a nutshell, this was a case which could have been nipped in the bud, as Supreme Court records in its 2021 order, that it's like a divorce case. And as we say that there need not to be any useless acrimony in divorce cases, this could have also been settled in a dignified way. But unfortunately, by the time they filed this application in Supreme Court, so that you please give us an exit utilizing Article 75, which they had already challenged before NCLT and NCLAT both, and even in Supreme Court. Supreme Court denied, and they said because the questions of law have been raised before us, which were these were 4 questions predominantly. So they rendered a judgment on 4 questions, and recently on May 19, 2022, the review application was also dismissed by the court. The counsel, Mrs. Salve, considered that few remarks against Mr. Mistry may be struck down. So those few remarks were struck down, and those were on the character, as Gupta sir pointed out. And this was it. That's how this was laid to rest.
Okay, Ravi. Madan, you have any point?
I know one thing, that as far as this incident is concerned, I'm not on the case right now, I'm on the incident, that we had to consume more than 200 man-hours in our Circle Standards Board. And because of this incident, we had to legislate the law on this any other item with the permission of the chair. And we changed the rules of the game as far as this any other item with the rules of the game, rules of the any other item with the permission of chair is concerned. Now Circle Standards provides absolute clarity on this, how this matter should be taken up at the board, what is the 3-layer permission which is required now. But I'm not happy to share with you that I address number of workshops for the directors. In 90% of the companies still, this item is being taken as per the old procedure. SS1 on this any other item with the permission of the chair is still not being adhered to. This is number 1. Coming to number 2 on NCLT, as I said, first of all, the law should clarify so that one need not run to NCLT and then NCLAT and then come back to NCLT, seek exemption, then go back to NCLT again, and third time, Mistry had to come to NCLT. It was a third instance that NCLT could hear this matter. Now here my observation is, it's a legal case. You have to decide this case on the law points. You can't decide on the basis of the character or on the basis of emotions or sentiments. If you read this entire judgment of NCLT Mumbai, it is more on emotions and sentiments. It starts the history of Tata from Jamsetji Tata. 200 years of history has been produced in the judgment. Literally it says, "Humne Tata ka namak khaya hai." Literally it says, you read the judgment, you will find it there. I mean, you need to decide on law points and not on the emotions and sentiments. And that might be one of the reasons that when they went to NCLAT and NCLAT overturned it. Anyway, now the dust has been settled. Supreme Court has already decided the appeal. One appeal of Tata's have been upheld. Actually, there were 2 appeals before Supreme Court. One appeal of Tata's have been upheld, and appeal of Cyrus Mistry, because against some portion of the NCLT judgment, appeals were preferred. Yes. Appeal of Cyrus Mistry was dismissed. And as Ravi said, he filed further some application also before NCLT, seeking some right for selling of stake on valuation of his stake. That application was also dismissed. And now lately he filed a review petition, and the review petition has also been dismissed. dust is settled. But I tell you, these three judgment, number one, NCLT judgment, number two, NCLT order in the appeal, and number three, Supreme Court judgment. All these three should be read together before you come to a conclusion.
Yes. Just one thing to add, sir.
Add that, see, there are two extremes. NCLT order was one extreme, NCLT order was another extreme. अगर एक ने टाटा का नमक खाया था तो दूसरे ने मिस्त्री का नमक खाया था, that is the situation. But probably Supreme Court ने किसी का नमक नहीं खाया था तो वो बीच में order आ गया है. I agree that one has to read all the three orders together to understand the whole situation. Because if you read one order, you find one picture. If you read the other order, you find the second picture. And if you read only Supreme Court order, you find the third picture. So you got to read it in a holistic manner. But I would say that this very clearly indicates the weakness of our legal system. If I was a judge, which I am unfortunately not, unfortunately also not for many, I would have asked the basic question in NCLT itself, that are you coming as a shareholder or are you coming as an aggrieved director who has been removed? Then I will decide the jurisdiction. If you are approaching me as a Cyrus mystery who has been removed, then your jurisdiction or appeal lies elsewhere. If you are coming as a shareholder, then the problem is that you were never a shareholder director. So I would have dismissed this thing in first case itself. But unfortunately, we have got legal system where depending upon how much is the lawyer being paid, then the judge allows time to this thing. So if you go with lawyers whom you pay 1 crore or 2 crore rupees, I will get 2 or 3 days hearing time without anything. So that is the problem with the judicial system.
Okay.
Nobody asked the question.
Okay. I think
It was asked.
all three person has given clearly point. Now I have, Sudhakar, you want to add something?
Only thing what I want to say is, I'm not talking about anything as far as the legalities are concerned, because enough discussions have taken place. Certainly there were certain governance issues were there with Tata Group. And had it been any other company, the regulators would have initiated some proceedings, some investigation proceedings and all. Sometimes when these kind of things happen, the size matters. If you are too big, nobody will touch you. If you are not too big, definitely there will be some kind of an issue. That is what my learning from this particular thing. Removal of an independent director, and no one has batted the eyelid. That somehow I couldn't digest as a professional, but of course there might be some reasons and all. And
I would say, Sudhakar, you have raised a very, very good point. And removal of independent director, I think it was only Nusli Wadia. Am I right?
Correct, sir.
And what happens when you are in a board as an independent director, the moment your independence gets compromised, you are neither an independent director and you are not fit to remain a director on the board. Now, Nusli Wadia, I will tell you, he was on the board of Tata Steel also. Now, if I am board of Tata Steel and you are also board of Tata Steel, and then you are making a public statement that Tata Steel balance sheet is fudged, it is wrong, and I have signed that balance sheet, what do? I own the responsibility. So did Nusli Wadia rebut Cyrus Mistry, or did Nusli Wadia take the responsibility that yes, he has signed the fudge balance sheet? On the other hand, he sided with Cyrus Mistry. The moment I am siding with two varying portions, I don't know, assuming that there was no judgment in the case. If two shareholders are fighting, Tata is saying something and Mistry is saying something. And if I, as a director, siding with one, then I got to accept the responsibility. He did not accept the responsibility that Mistry is right. Yes, I have fudged the balance sheet of Tata Steel and 20 billion is the whole, and I submit myself to the law for signing the balance sheet. One. Second thing, probably many people are not aware, Nusli Wadia was on the board of Indian Hotels for a long time. an Indian hotel had a deal with Land Sea Rock Hotel. And Sea Rock Hotel deal, we had criticized in our report all the time. We had criticized Tata for that deal. He was part of that deal. He was there who had approved all those things. When Cyrus Mistry started doing something, then he said, yes, there are legacy problems in Indian hotel. Now, what you were doing? So, in my opinion, you were never a fit person to be a director, whether independent or non-independent anyway. That's why I said he should be removed as a director, because one, a board of director cannot be divided into Hindustan and Pakistan, that I as an independent director on the side of Mistry, Sudhakar as an independent director is on the side of Tata, and then we draw swords and cut each other's neck. No. So the board cannot be Pakistan, Hindustan. I have
only,
to be
only one question to you, sir. Please throw some light on that also is, when the directors and the chairperson themselves are making some kind of an allegations as far as accounts are concerned, why no regulator has taken any suo moto, what's called as interest or whatever it is, and
I would have loved to that. I would tell, then in that case, probably there would have been some criminal cases against Mr. Mistry, which he has been saved off. Because today Tata Steel balance sheet is not showing any $20 billion hole or whatever $1 billion hole he was saying. So there is no hole. So then he would be under a criminal problem. So at least he has been saved of that problem.
We are not talking about whether he saved or whether he has been screwed up and all. What we are saying is, in general, when the companies, this kind of things comes, some kind of...
I agree. So see, we do not know what is the whole story.
Correct, sir.
We know only what is in the public domain. We do not know what Tata would have gone and shown to the thing, or what audit report was submitted to SEBI or MC or something. People would have been satisfied that this is not wrong, because it is an allegation. And Cyrus Mistry has not backed his allegation. Because if you are making an allegation that company A has a hole, then you back your allegation. And the moment you back your allegation, you are signing your death warrant, because you have signed that balance sheet.
True.
Okay. So it was an allegation making jest.
Okay, now, Madan, I have 25 questions, so we have to just cover, and time is already over.
No, majority of these questions are observations. Some of the questions have already been answered by me as for IBC.
Just for the sake of certain answer, I know we have given. Let me just take up this question related to MCA circular on AGM VC mode up to 31st December, followed by SEBI circular and dispatch of hard copy annual report and shareholder. If we hold a physical AGM, can I utilize the exemption provided by SEBI on dispatch of annual report? Simple question, Amit. I will hold the meeting on VC.
I will answer logically no. Now, can I leave if there is no question to me?
Yeah, you can read.
Okay, thank you. Thank you, everybody.
Thank you, sir.
Okay. So, anybody clear answer? If I want to hold the meeting,
discuss this issue, I think, while we were discussing this.
What is the question, Pawan? Can you please repeat?
I want to hold the meeting for AGM, but display. I want to hold the physical meeting, but dispatch the notice through email.
According to me, he cannot.
Okay. Any other different view? So the friend's answer is no. Does the restriction apply to existing directorship by such directorship as well as the reappointment? Ankit?
Why should there be restriction? Why can't you hold a meeting in physical mode if you're sending them notice through electronic mode?
Sir, because as per the circular which was there, which allows you to send the notice.
Sir, according to me, the circular should be read in such a way that they have given you both the exemptions. It does not be either you avail both the exemptions, or one of the exemptions will not be available to you. That should not be the intention of the circular.
Please read the circular, GP. The circular says it is to be complied in its entirety. You cannot do pick and choose.
But then you want to do certain things physically and sending this, because those who are coming for physical meeting, they want to see the balance sheet also.
No, that's
Both
what
are
I'm saying.
independent
That's what I'm
actions.
saying.
Sending the annual report and holding the AGM are two absolutely
Totally
different
different things.
actions.
Yes, sir. Yes, sir.
It's not the
These
same
are
thing.
two different
No,
things.
no, GP, listen. What I'm trying to say is when you are in a position to hold the physical meeting, you are in a position to dispatch the physical annual reports. You cannot say, I will hold physical meeting and I will not dispatch physical annual reports.
No, sir.
But sir, it is
cannot do
not
that.
about the ability. It is my choice and my saving, my
I think
cost
Manoj,
saving
the
strategy.
choice was provided considering at that point of time there were
Correct.
certain provisions with respect to moving
Right.
of goods. Now everybody is ordering anything from e-commerce and you don't want to send it to.
Okay. I just take a view. Amit, you are in favor that you can do both the things simultaneously.
In spirit, I strongly feel what Madan sir is saying. Yes, it is possible. But in law, there is a gap.
Okay. Sudhakar, you are saying both you can send. Ankit, you are saying both.
I think both.
Both you can.
So you have to, if you are doing it physically, you have to send it physically.
Okay, Madan, you are both. Manoj, you are also supporting both way.
Yes.
And
No, I am saying yes. Physical e-meeting, sending of notice and report is one part, and holding meeting is totally different.
yes, the same. So you are saying both are separate. Anjali,
Yes,
you.
both are separate.
They're separate.
So majorities both are separate. We should take the view from the clarification from the government. So okay. So because this is a gap, all people are taking a different interpretation. So Ravi, you have any interpretation on this?
Yes, I agree with what Manoj sir and Madan sir is saying. I see that these two are different things. They can't be correlated. There's no correlation between these two.
So let's clarify from the government on this. No, we don't share land border. This is comment. Land bordering. If there is any specific process for getting MHA approval for appointing director on Chinese national, Ankit?
No such procedure is outlined on the website, but I believe you have to visit the
Ankit, be a bit louder. We can't hear you.
Most probably you have to visit the MHA office. I think at Patiala. I used to visit there for security clearance earlier. I don't know what's the current address, but as on the site, I have visited the site. There is no such online process which can be adopted.
Okay. But anybody has done this exercise?
MHA approval may be required a number of other incidents also, not under company. But I think there should be some clear-cut format and procedure for that.
Yeah, there is an application form. There is an application form for seeking security clearance.
Okay. One person has commented that permission of MHA itself means having a comprehensive checkup on the transaction. That is correct. Demat account KYC regulation must have mandated for restricted transfer of person who are citizen of country which shares land border with India.
I think Sudhakar sir raised this point that this also needs to be changed.
Okay. Ankit, is a approval from MHA for directors having DIN also required?
No, if they are supposed to be appointed, I think it should be required.
Yes. For consent, DIR
Yes.
you are required now.
Okay. And somebody has sent ECB also taken care by RBI, so they
But
can.
then in that case, if you need a MHA approval at the time of getting the DIN, then why approval is required before appointment? Then that should
No, sir. If you have taken at the time of obtaining DIN, if you already have DIN, but you are taking a fresh position in any company, you still required to have a fresh security clearance.
Madan is asking the question. I can take a DIN. So taking DIN itself is a requirement of MHA, or when I'm becoming a director.
So they are creating multiple layers, sir. While at the stage of obtaining DIN, also they are putting a check, and also at the time of appointment of a director. So,
but I think, sir,
if you are already having a DIN, so at the time of appointment you will require a security clearance. But if you are not having a DIN, so at the time of obtaining DIN, you are required to have a security clearance for the later purpose. You will not require separately.
No, but the only issue is, for example, I have applied DIN in 2020. At that point of time, I have been giving a security clearance. I didn't take any position of director till 2022. Now I am taking a position as 22, or it may be a future case. My security position might have changed during this period.
Correct.
It means at the time of appointment,
yes,
one must have valid.
Yeah, that should be the case. But then, sure, but what should be the period? For example, if I have taken the clearance in the month of June, and now I'm again seeking an appointment in, for example, August or September, do every time I need to seek a security clearance?
Ankit, I think we need to approach
There is a
MHA.
Yes.
Whether MHA is giving approval for 6 months or 1 year or for lifetime, I think we need to.
That needs to be looked
check
into.
from there. Yeah.
So that you can write, Ankit, that you can write in your CP Connect after getting the information.
Yes.
Okay. Some people have commented that the ECB also taken care by RBI, SB also we controlled. So all these things, they are suggesting that they should also do like people are giving ECB. So whether ECB, FDI or not, that's one question. SBO also we control. That's another suggestion. And to avoid a bit too economically apparent takeover strategic business, they want to bring out these changes. Ministry of Home Affairs is working in direction to control and review. So that is also right. When we say company can held EGM through BC, now it is mandatory to use postal ballot for the item specified in section 1010 of Companies Act. Amit, any comments on this?
Sir, that mandation is removed post introduction of e-voting.
Okay. ESG required to amend the law to send hard copy of annual report of 100%. It should be through email only. This way country can go away digital era. That is also a comment
I
somebody.
think that is part of the Company Law Review Committee's recommendation. So that will come.
Okay. Ankit, CSR2 form compliance required, whatever you have given, any other point?
No, it's
Now
it's
is only
it's just a replica of the annual report and more extended. Amit ji has done better research on this. If is an additional point he want to add.
Yeah, I think a lot of checkpoints are there. You need to, whatever precautions you have taken with regard to CSR2 for 2021, I think same needs to be followed for 21-22 also. As far as filing of the form is concerned, there are many issues which I believe we had taken a long discussion in the previous session also.
Okay.
That may be referred.
The business correspondent company requires section 25 or obligate as per BI guidelines. Is business correspondent company need to be section 8 company?
Not necessary.
Not necessary.
Okay. In the recent case of Sabri Rubber Private Limited versus Prem Puja Trader Private Limited before NCLT Kochi, NCLT has required 2 of the 13 amalgamated company to hold creditors meeting where there was no NOC from the creditor. Your view, Manoj?
Yeah, it is a standard process. If there is no NOC, obviously meeting would be called upon. That is the process of law.
Okay.
So, yes.
Okay. Shareholder resolution is of subsidy should be taken. Procedure standardized. UPI time is this can mainly a UPI. There is an issue of SEBI for purpose of financing HNI. One of with regard to security clearance. For defense product manufacturing, we have done security clearance. So somebody has said this way. Each time you need to take security clearance. So the point was each time you have to take a security clearance. Security clearance, they are giving gives timeline also that this is valid for how many days. So
I think, Ankit, you can speak to Amita. Amita has given these comments. You can be in touch with her.
Amita Desai, she's excellent professional and she has a very research-oriented profession. So Ankit, you can talk to her.
I will.
She's suggesting, which will be helpful. So friends, thank you very much. The way we have clarified all the points, and I hope that within next 2 or 3 programs, we will structured more structured way and the more effective way. So today, we have discussed the new law. What is this law? What is its impact? If this issue is creating the new law is creating any problem, and the case law of that particular period, which is very important. So we will improve further. You can suggest us, and I request panelists also, you can also tell us that how we can make an improvement. So one law, one discussion, then we'll move on second, which we have done. So if there is any improvement you require, please tell us. Any other topic you want to cover, any other point you want to cover. Now, whatever we are discussing today, you will get in our CP Connect. And that is the updation of this particular month. So you can take advantage, and we will take advantage of this program, and we will clarify certain more point, which is there is a confusion like one point, people are divided, they were not uniformity. So we will bring out these clarity. And friends, whatever we are discussing, we will compile it if there's any confusion and send it to the Ministry of SEBI or IBC, that these are the issues which are creating confusion in the minds of audience and the user. Please clarify this, or whatever clarification we'll receive, we'll pass on to you. So thank you very much to all my participants. Thank you very much, all my dignitaries, speaker, delegates. So Amit Gupta, Mr.
Thank you,
Jeev
sir.
Pradhan, Mr. Sudhakar, Manoj, Ankit, Anjali, and Ravi.
Thank you.
Thank you very much. Friends, we will continue our journey of this, and the next webinar we are organizing on valuation, because valuation is now is a buzzword, and everywhere, every transaction require valuation, which is a regulatory transaction or it's a commercial transaction. And the new concept is also coming out that everybody wants to understand his valuation. So in this program, we will discuss concept of voluntary valuation and the valuation of various aspects and how the trend is going on. So next week, same time, 4 to 6, we'll meet and we'll discuss about the valuation in as a whole and the issues connected to valuation and how the valuation is taking place, what are the issues, what are the points, and the valuation concept should be, it's a concept where whether Mr. Madan is an advocate, whether Sudhakar is a company secretary, practicing company secretary Amit, or other people, everybody should know that valuation is one area. You are disputing with anybody, you require valuation. You are doing any transaction, you require valuation. You have a future transaction, you require valuation. You have some dispute in the court and the court is asking certain issue that you require valuation. So everybody who is sitting here, he require valuation. Gupta ji has left. He is also seeing whether the valuation is high or low. That is also. So now valuation is a part and parcel of each and every process. So next week, we will discuss this issue in detail. Thank you very much. Till then.
Thank you.
Thank you.